Yeah. Good evening, friends, and it's always a pleasure connecting with Justice V. Kumar, who we always say that is an epitome of knowledge. And day in and day out, you can bother him for the purposes of asking him on any legal perspective of law, and his passion to pay back to the society. What we say in the corporate world, CSR, that is corporate social responsibility. I feel that he has taken an onerous task of legal social responsibility, LSR. And for that, we keep on asking him and requesting him to take the sessions. And off late, since he's quite busy, as well as taking his passions with short question and answers on the virtual mode, despite all this, we request him, and yet he always exceeds it. And that gives us a pleasure that he accedes to us, and we exceed in our request that he should take on sessions. And today's session is on the forfeiture of the bail bond, section 446 of Cr.P.C, which is a very short topic. And we are experimenting it, that we have not shared the Zoom link, and straight away we are going live on the YouTube as well as Facebook. I'll request sir to share his insights. Over to you.
Thank you, Mr. Vikas. Good evening, friends. Today we are on forfeiture of bail bond, covered by section 446 of Cr.P.C. See, there is a lot of confusion among many members of the bench and the bar as to what exactly is a bail order and bail bond, and what exactly is the cancellation of the bond and cancellation of the bail order. There is a lot of confusion. So my endeavor will be to steer clear of those confusions. Okay, a person released on bail with or without sureties has to execute a bond for such amount as the police officer or court thinks sufficient. This is what clause 1 of section 440 Cr.P.C says. The amount of bond shall be fixed with due regard to the circumstances of the case and shall not be excessive. This is what section 440 clause 1 says. Such a bond is to be executed in terms of form number 45 of the second schedule to Cr.P.C, as per which the accused and his sureties undertake that the accused will attend the police officer or the court, as the case may be, on every day on which there is investigation or trial, as the case may be. And the explanation to section 446 clause 1 Cr.P.C clarifies that a condition in the bond for appearance shall be construed as including a condition for appearance before any court to which the case may subsequently be transferred. The further undertaking by the accused and the sureties is that in the event of any default made by the accused to appear before the police or the court, the accused as well as his surety shall forfeit to the government the amount fixed by the court as the bond amount. Therefore, there is a separate contract between the accused and the government and the sureties and the government. The contract is, the accused will say, I shall, without any failure, appear before the police officer or the court, as the case may be, on all the dates of posting, on all the dates of investigation. And in the event of my committing default, I shall forfeit to the government the sum fixed as bond amount to the that is the undertaking by the accused. Sureties will also make a similar undertaking. Both are incorporated in form number 45 of the second schedule to Cr.P.C. So the sureties will also undertake that in the event of the accused not appearing before the police officer or the court, they will also forfeit to the government the amount fixed as bond amount. So that there is a sort of an undertaking, and not only that, there is an assurance by the accused as well as the sureties that the accused will faithfully and without any default appear before the police officer or the court, as the case may be. Now, the Supreme Court has had occasion to consider this, and the Supreme Court speaking through Justice K.T. Thomas, in two decisions, has highlighted this aspect of the matter. The Supreme Court, speaking through Justice K.T. Thomas, has held that this is an independent contract between the accused and the government and the sureties and the government. You may refer to Ramlal versus State of UP, AIR 1979 Supreme Court 1498, 1498. As Murtaza Fazal Ali, O Chinnappa Reddy, that is one decision. Then Muhammad Kunju versus State of Karnataka, AIR 2000 Supreme Court, page 6, Justice K.T. Thomas and M.B. Shah. Author of the judgment is Justice K.T. Thomas. Now, any breach of the condition for appearance will result in the automatic forfeiture of the bond in view of the self-explanatory wording of form number 47 of the second schedule to Cr.P.C, rendering the accused and the sureties liable for action under section 446 Cr.P.C. Such a breach may also entail automatic cancellation of the bond by the operation of section 446 capital A 1 Cr.P.C. See, I have told you the accused and the sureties have entered into separate undertaking between the government, and the undertaking is the accused shall faithfully appear before the police officer or the court, as the case may be, without any default. And in the event of the accused committing any breach in this condition, the accused as well as the sureties will forfeit to the government the amount fixed in the bond amount. That is the undertaking. So this has been highlighted in those two rulings. Now, once how is the bond forfeited? Now, for forfeiture of the bail bond, you don't require any separate order. Court doesn't have to pass a separate order. Once the accused remains absent, his undertaking is that he shall regularly appear before the police officer or the court on the appointed days. Now, supposing the accused remains absent on a particular day, then his absence is evidence of his breach. He has committed breach of the undertaking by remaining absent without any excuse. So he has committed breach. Once he commits breach of the undertaking, forfeiture is automatic. The court does not have to pass any separate order. Why did you remain absent? What are the reasons for your absence? No. Once he remains absent, he has already committed breach of the condition for appearance. Therefore, you under Form 45, the contract is entered into under Form 45. Then Form 47, second schedule Cr.P.C, indicates that once he has failed to appear, the bond is automatically forfeited. Then what remains is the forfeiture part of it. The court will be entitled to recover the bond amount by way of penalty. Now, regarding the recovery part, he is entitled to notice because there may be valid reasons for the accused not appearing before the police officer or the court. Now, certain offbeat decisions were taken in the High Court of Kerala to the effect that upon breach of condition for appearance, the accused and the sureties are entitled to be served by 2 show cause notices. There were some decisions taken by the Kerala High Court. Of course, but there are other High Courts also to the effect that once the accused remains absent, he has to be given a notice as to why he remained absent. Then only the forfeiture takes place. No, those decisions do not lay down the law correctly, because once he remains absent, he has committed breach of the condition for appearance, and the forfeiture is automatic. Once the bond, remains absent, bond is automatically forfeited. What remains is to recover the penalty. For recovery of the penalty in whole or in part, the court will have to hear him, give him a notice. Why should I not invoke the penalty clause and recover the entire amount by way of penalty? There the accused will have valid reasons as to why the entire amount should not be recovered, or not even a pie should be recovered. Now the separate decisions, this decision which held that accused is entitled to 2 notices, one before forfeiture and the other after forfeiture were overruled by a larger bench of the Kerala High Court in Tundichi versus State of Kerala, 2009, 4 KLT 67, presided over by the then Chief Justice S.R. Banur Math and A.K. Bashir. Justice Banur Math is the author of the judgment. Now, this after the division bench ruling, nobody can argue, no accused can argue, or no surety can argue that he is entitled to two notices, one before forfeiture and another after forfeiture. He is entitled to only one notice, that is after the automatic forfeiture of the bail bond. As mentioned earlier, the only notice which the accused and the sureties are entitled to, consequent on the forfeiture of the bond, is a show cause notice to be issued under section 446 clause 1 Cr.P.C, calling upon them to pay the penalty which they had undertaken to forfeit to the government, consequent on the absence of the accused. Once such a show cause notice is issued to them, they can show valid reasons, if any, for not paying the penalty wholly or in part. They can show reasons such as the accused was affected with cancer or COVID pandemic or with such other deadly disease. Therefore, he was unable to appear before the court or before the police officer. One reason. Another reason can be the parents or the spouse of the accused had expired. So he had to attend on them. So he couldn't appear. Or there could be a third reason. It was a Hartal day on which there was no public transport system. So he could not get a bus to reach the court or the police station. That can be a valid reason. Or there can be still another important reason. On that day, appointed day, where he was to appear before the police officer or the court, he was actually in custody in some other case. So physically impossible for him to appear before the police officer or the court. These are all, there may be other reasons also. These are all valid reasons which dissuade the accused from appearing before the court. These reasons are available to the accused in the show cause notice issued to him after the forfeiture of the bond. And he can say that, see, I was actually in custody in some other case. So I never knew that there is such a posting. So kindly excuse my absence. Court can say that, no, okay, there's a valid reason. He was actually on custody in some other case. He was in the prison. Therefore, he nobody can expect him to be present before the police officer or before the court. Therefore, he is excused. So no amount will be recovered from him. Court can give a total remission of the amount. Now, depending on the truth or otherwise of the reasons put forward by the accused and the sureties, court may either wholly or in part remit the penalty under section 446 3 Cr.P.C. If partial remission alone has been made, then the court can enforce payment of the unremitted part of the penalty. The penalty ordered by the court under section 446 3 Cr.P.C. shall be recovered as if it were a fine imposed under the code. You refer to section 446 clause 2 Cr.P.C. Then section 431 Cr.P.C. is the provision for recovery of money other than fine payable under the Cr.P.C. Such money is to be recovered as if it were a fine by resort to section 421 Cr.P.C, which is the provision for recovery of fine by, now the mode of recovery is by attachment and sale of the movable property of the offender, one mode, or issue of a warrant to the collector authorizing him to realize the amount as an arrear of land revenue from the movable as well as immovable properties of the defaulter. Now, one important aspect to be borne in mind is that if the penalty is not paid and it cannot be recovered at all, because even after resorting to attachment and sale, etc., if the court finds that the penalty cannot be recovered in the manner stated above, then the surety alone is liable to be imprisoned in civil prison for a term not exceeding 6 months. Accused is not liable to be imprisoned in civil prison for non-payment of penalty. Surety, of course, will be liable to be imprisoned in civil prison for a term not exceeding 6 months. 6 months is the outer limit for being imprisoned in civil prison. the accused is not liable to be imprisoned because of the wording of the proviso to section 446 to Cr.P.C. This is the mechanics of the forfeiture of the bail bond. So, when the bond is for appearance and the accused remains absent, contrary to the undertaking given by him to the government through the instrumentality of the court, then he will forfeit to the government the bond amount. That forfeiture is automatic because of the court can visibly see he will be absent in the dock. That itself is proof of for the default, proof of breach of the condition for appearance. And then the forfeiture is automatic. After forfeiture, court will ask him, call upon him to pay the penalty, to pay the entire amount as penalty. Then he can be heard to say that whether he has got valid reason as to why the penalty should be or should not be enforced. This is the mechanics of forfeiture of the bail bond. Now, next time we will be considering the cancellation of the bail order. There's wide difference between these two. Forfeiture of the bail bond resulting in the consequent cancellation of the bond and cancellation of the bail order itself are two different things. Next, in the next session, we will examine the principles of cancellation of the bail order. When the accused, after being enlarged on bail, he commits default or he commits he violates one or more of the bail conditions, then it is not a of course, if it is for appearance, then there is a forfeiture of the bail bond. But if it is supposing he has been asked to report before the police officer once in a week and he does not report, then it is a violation. Once he violates the conditions in the bail order, then he is liable to be, the bail order is liable to be cancelled. We will examine that in the next session. So I suppose that you have got a full understanding of the mechanics of the forfeiture of the bail bond. Thank you.
Yes, sir. So only one question has come.
Yes.
It says, can a court put conditions in bailable offences? What is the difference between terms and conditions for bail?
Bailable offences, there can't be no condition can be imposed except a condition for appearance on such particular date. On such and such date, you shall appear before the police officer or before the court. That is the only condition which can be imposed in a bailable offence, because bailable offence means he is entitled to bail as of right. Once the offence is found to be bailable, he is entitled to bail as of right. No court can refuse him bail. Only thing is, if he is not able to furnish sureties, supposing court insists on sureties, if he is not able to furnish sureties, because he may remain in custody. Otherwise, he is entitled to bail. But unlike in the case of a non-bailable offence covered by section 437, there the bail is not as of right, it is the discretion of the court. Whereas bailable offence falling under section 436 Cr.P.C, where the accused is entitled to bail as of right. Yes.
Yeah. So thank you, friends, for connecting with us. And those who have missed our previous webinars can always like, subscribe, and share the videos so that we also come to know that what you are liking. And in case you want any other webinar on any topic with good resource persons, you can always drop a message on the WhatsApp or on the YouTube link itself. We would be too glad to convince the speaker. And we know that there are too many speakers like Justice Kumar who accede to our request for sharing his knowledge. Thank you, everyone. Stay safe, stay blessed. Namaskar.